On the record?
Yeah, so if you can get the ring call. All right, and so we are going on the record in the matter of Dylan Bolchek, Angela LeBeau, and Madison Ronick, 22754. And Mr. Bolchek, your name, please.
Valentin Bolchek.
All right, thank you. And Miss LeBeau, your name, please.
Angela LeBeau.
All right, Miss Ronick, your name, please.
Madison.
Last name.
Ronick.
All right, thank you. All right, and today's the date for the date time for the second hearing. And Ms. Ronick, are you in school right now?
No, I'm actually at work, and I clocked out at 8:30, so I missed pretty much all my day, and I'm kind of worried about that because now I don't get paid for those hours that I missed.
Okay, well, I do apologize, but clearly there's a lot of people on the docket today. It's not as though we haven't been handling these matters.
I know, it's no problem.
So, all right, and so what's happening, Mr. Bolchek?
We spoke earlier and there doesn't seem to be an agreement made. They want more time than I'm willing to give them at this point because I feel like I've already given them plenty of time. So I'm waiting a judgment to see if when they would be able to leave.
All right, so if I recall correctly, you moved your dad in and then Ms. LeBeau and Ms. Ronick moved in as well, correct?
Yes.
And so Ms. LeBeau, how much extra time are you asking for?
Okay, I just started my job and I don't get paid until the 17th of June.
Yeah, my question was, how much extra time are you asking for?
Okay, I mean, until we
days.
get the money to move.
30
It
days.
could be like 3 or 4 weeks.
Three or 4 weeks.
Yes, because I'm just,
You were served with a notice to quit on March 18th for 30 days.
Well,
You didn't move out
right.
then, and now we are at just about another 30 days already. So that's been 60 days already.
okay, can I please explain something? You know, I'm not trying to be rude or anything, but living in this house has been very negative. But since the eviction started, there hasn't been a negativity. It's hard to function like that. And we were looking for jobs. Okay, go ahead.
I just got my first paycheck last week, and I won't be getting paid again till the 20th. And I just wanted to save up my money before having to move. I understand that he's told us to leave, and I'm sorry that I didn't leave when I was told.
I can
I'm
only
sorry.
have one of you speaking at a time, please. Ms.
Okay.
LeBeau, if Madison's speaking, I cannot have you speaking also.
Okay, I'm sorry. But I don't get paid. I get paid bi-weekly and they hold back a check. I won't get a full check till June 17th. And my daughter can't do it by herself.
Mr. Bolchek, you're asking for the 10 days?
I was
May
going
23rd?
to give them actually until the end of May, which would be 15 months since I've asked them to leave the first time. And they've been staying here rent-free for the last 20 months. So I feel like I've given them more than enough time to give them through the end of this month.
All right, well, so that would be an extra 8 days on top of the 10 days, so that'd be 18 days. And so Ms. Ronick, you have Ms. Ronick and Ms. LeBeau, you have until May 31st to move out.
Okay, what happens if we don't have the money by then?
Then we're homeless. They don't care.
Ms. Ronick?
She said,
Hearing is not one of the elements that this court has to determine before the court signs an order. So whether the court cares or not, that's not relevant before the court enters an order. So The court is going
I'm
to
sorry,
indicate-
what did you say?
But caring where you go is not an element as to
Oh, I know.
whether or not the court signs a judgment. Mr. Balchek has given you an
Okay.
extra 8 days over the statutory 10 days that this court, if the court entered an order today and Mr. Balchek didn't want to give you that extra time, you have to be out on the 23rd.
So what,
So,
so I have to be out on the 31st.
The 31st. So the court does find after
They don't care about
hearing that the plaintiff is entitled to possession of the property, the amount, or I'm sorry, if the defendants do not move out on or before May 31st, the plaintiff may apply for order evicting the defendants.
Wait, what?
No money judgment will be entered at this time. There may be additional money owed if damage to the property occurs. And you're all set. Thank you.
Thank you.
We don't understand what
All
that
right,
meant.
I don't know.
We don't know what that meant, Your Honor. We don't know what you mean.
It means that you have to move out by May 31st, and if you don't, then Mr. Bolchek can apply for an order evicting you.
Okay.
All right, thank you. Have a good day. Off the record.
We can't get an attorney? That's wrong. No, because there's more to this than what is being said.
We're going back on the record.
On the record, I didn't go off.
Okay, 22754. Man, you certainly have the right to have an attorney. And in fact, there have been multiple dates. You've had multiple times to notify an attorney or contact an attorney. You absolutely have that right. But today is the date and time that we're moving forward. Mr. Bolchek doesn't have an attorney, and you haven't requested an attorney prior to now. But you certainly have time. You can hire an attorney. That attorney can file any motion that they like to file. And
also I'm asking for was just wait till I was to get paid, because we would not have enough money to move. And if we live in the car, we can't get ready for work, so then we'll lose our job.
No, I'm gonna
Okay,
lose,
well,
I'll lose
excuse
everything.
me, just one moment. Not even going with what Mr. Bolchek said about 20 months ago, asking you to leave. I'm not even going
Can I ask-
there.
I would like to
March-
see.
In March, you were served with a 30-day notice to quit. You didn't move. Then there was
Okay, I
another
would like-
action filed. So it's been almost 60 days since you were first officially notified in writing that he wanted you to relocate.
Okay, but you don't, there's so much more to
Okay,
this
she don't care.
that I'm not allowed to say. It's the reason why we didn't get out a long time ago. And it's not just because I didn't help his dad, because I helped his dad. And there's a reason why.
Ma'am,
we
do
didn't
you
get
have a
there.
legal defense as to why you should not have to move? Do you have an ownership interest in the property?
No, I do not. But there's
Just
a
hang
lot.
up. Cause it's over.
No, it's not.
I cannot have you both talking at the same time. I've already indicated that.
No.
Okay, there's a lot more to this. And it's not like we just sat there and did nothing, or nothing happened to distract us from doing what we needed to do.
I don't understand what that means.
Okay, first of all, my daughter in April of last year had a job, and he was screaming at us. He has punched counters. He's called me names. And the only reason he stopped is because there's an eviction right now. It is hard to work under such negative, and the way the house is, I mean, it's so negative. People look at you like they hate you. Yes.
Mr. Lowe, do you hear what you're saying? I'm not sure
Yes.
why you didn't move out sooner then.
Because
You
I was helping his dad. No one was helping him. I got him asking me to help him like every other day to do everything, which I didn't mind, but I shouldn't have helped him. It also did was cost me. But I made that mistake.
If I may
Not
say,
that
if I may say, I understand that you have helped with my father and stuff like that.
And I wanted to. I'm not.
And in return, I've allowed you, in return, I've allowed you to stay here for free without paying rent or utilities in any way.
Well, I didn't ask to move there either. Like you said, we needed to stay there for a couple months. That wasn't true either. And if that was true, we were told something completely different. And I'm not mad at you. I understand. I don't like to live with other people either. It is very uncomfortable. But we don't get paid, and we can't live in our car.
Excuse me. Can I talk for a second?
That's insane.
May I be excused?
Excuse me, what's that?
Yes, I'm sorry.
What was Madison saying?
I said, I'm sorry. My daughter she's crying. She's trying to get back and work. You can't leave until we're done.
Okay, no, we're done because the court's entered its order and
Okay.
There isn't any legal defense to that. He's given you extra time. And so the court's entering its order.
Okay.
All right, thank you.
Bye.
All right, have a good day.
I
All right,
would-
then we have Philip Potter and Donna Potter.
I'm fine on the claim.
I have one more.
I'm fine on the claim. Because then I can get my money.
How do you do this?
I don't know how to turn it off. I am doing it. I'm gonna go get the welfare department will help us. They already said they would. I didn't want to go to that route.
Okay. Are you ready with Ms. Stevenson?
I am, Your Honor.
Okay, all right, give me just one moment. I just need to step off and use the restroom, just one moment.
Sure, absolutely.
And then we are still on the record, Warwick's Townhomes versus Marquia Stevenson on all occupants, 22360.
Marquise Burnett Stevenson, Your Honor.
All right, thank you. So, this is another adjourned date. I know that, that there were some concerns as to where the check was at, because the check was lost. And then we set it for review today because Ms. Luckoff was potentially going to be filing a show cause with Wayne Metro, against Wayne Metro, right?
Yes,
Right,
Your Honor.
My client did not want me to file a show cause, but I have finally a contact at Wayne Metro who's actually been appearing in another court who will be working on this. What I'm told, and I think the court is aware of this, that if we have a judgment, and I did not discuss this with Ms. Stevenson, I realized after the breakout room, it will expedite the matter. It's Darla Reimke from Wayne Metro, who's been assisting with some of these cases. I mean, this check is lost and it's going on for months. So what I would ask is for the entry either of a judgment or a conditional dismissal, whatever the court prefers. And I would submit that if the court was so inclined, we could even put in there, well, we shouldn't put in there, but I can put on the record that we would not file a writ without a motion. I think the only way to get some finality is to light a fire and have a judgment or a conditional dismissal. That's what this Sarah specialist has been doing in my other cases.
Okay, and I will note that the court is familiar with Ms. Remke. She does log in at this court as well. However, she was on here this morning, but had to log off at 10 for a mandatory meeting. So I was hoping that she would have still been on when you were here, counsel, so that could have been a little bit more direct right there. But
I did email her, Your Honor. So
okay,
I'm waiting to hear back.
So Ms. Stevenson, have you had any other information?
I called Wayne Metro 2 days prior to the court date of today, and they said they gave me a tracking number, which the check was mailed to a Livonia office on the 14th of April. And I was like, that is a totally different tracking number from what was given to me before. I contacted Melissa and she told me that she would contact their attorney and she will update them on what's going on. And she said that she did try to go and pick it up several times for the leasing manager or the leasing office or corporate, but she said that it's not ready yet. Mm-hmm.
So here's, to be honest, Ms. Lugov, I'm not sure which is the best way to go, a judgment or a conditional dismissal. I don't know. I mean, I think for Ms. Stevenson's benefit, it probably would be a conditional dismissal, but as far as for that purpose, but perhaps a judgment will also work to Ms. Stevenson's benefit to get things moving a little faster. I don't.
My experience is a judgment speaks louder than a conditional dismissal. I would submit that we can even put in, well, again, I don't know if I want to put in here, but I put in the record that we'll set aside the judgment if it's satisfied. So she doesn't have that on her record. But I'm going to request a judgment. I think it's our best bet here.
I
I would
understand.
agree that a judgment would be probably the most benefit all around. I would indicate that that as you placed on the record, that would be placed in the judgment as well. That
Okay.
if it's satisfied, the judgment will be set aside. Also, if there's going to be a writ, then that would have to be set up as a motion, just so we can have it all on the record, because it's been a SERA issue and the check, there's not a dispute, the check was lost. So that would have to just be set as a hearing then, instead of just submitted to the court.
What we've been doing in these situations, Your Honor, I have no problem putting, we'll set aside the dismissal, the default in the judgment, but I've not been putting in the writ hearing because then Sarah knows it's going to be time before we do anything. I'll do it however the court wants it, but we've been putting it in the register of actions and on the record, that we must file a motion.
Yeah, so that, so I understand that part of it as well. So I will indicate in the register of actions that in the event a writ is submitted, it's not to enter until there's information on our end regarding SERA. So, okay. I'm going to indicate then that a consent judgment will enter, because you're in agreement with that, correct, Ms. Stevenson?
I mean, if it's going to get them paid, I rather them get their money. Yes, Your Honor.
Okay, all right. So consent judgment to enter regarding provision or with provision regarding set aside. All right, and then what date did you indicate that you're putting in there, Ms. Lugoff?
I don't believe I did, Your Honor. Why don't we do a May 31st, or we can just do the 23rd, however the court feels would be appropriate. Perhaps a shorter window would be better in this situation.
Well, if you're in agreement, Ms. Lugoff, I think that the 31st would be a bit better, just because.
That's fine. That's fine.
Yeah, okay, all right. Okay, and so then, Ms. Stevenson, you understand the terms that have been placed?
Yes, Your Honor, I understand what's going on.
The court will indicate then that by consent that the plaintiff does have a right to recover possession of the property. And Ms. Lugoff, I'm sorry, what's the amount due?
Your Honor, rent to retain possession is $5,124. Court costs $155. The total redemption figure $5,279.
Okay. And then if that amount is not paid or defendant does not move out on or before May 31st, plaintiff will apply for an order evicting the defendant. No money judgment will be entered at this time. Partial payment will not prevent the court from issuing an order evicting the defendant. Absent the information of SERA, there may be additional rent owed. And the court will also note that there's an agreement that if once the SERA money is once the rent has been paid, then there will be an order entered setting aside the judgment. And the court's going to also indicate, I know this will not be in the judgment itself, so that it doesn't interfere with having SERA moving quickly, that the court's not going to sign any writ until there's confirmation with SERA regarding the payment or location of the check. That's in the register of action. I know that will not be in the judgment, that last portion. And does that represent the judgment, Ms. Lugoff?
Yes, it does, Your Honor. And I'm not sure if the court is comfortable with me and Ms. Stevenson's comfortable with me signing on her behalf, or how you want to handle that aspect of it.
Comfortable.
Okay, what I would suggest though, counsel, is just emailing that to Ms. Stevenson and then having her just respond in the email that she's okay with you signing her name to that.
Okay.
Then And Ms. Stevenson, you understand that Ms. Buckoff, as helpful as she's been, she still represents the interests of the plaintiff and not your interest. Do you understand that?
Yes, Your Honor, I totally understand. So just for clarification, it's that it needs to be paid before the 31st, and if not, then we will have to come back and make a decision on what we're going to do next, as far as me living here, basically, right? Mhm.
Well, you may or may not come back. If the court determines it's gonna set a hearing, then the court will do that. I'm not putting that in the judgment because I don't want, the people that see the judgment that have to process it to think that there's extra time. We want them, I mean, it's been an urgent matter, but it doesn't seem to have been taken as an urgent matter. So with the shorter time frame, it will be as a sense of urgency. So the court may, if the money is not paid and plaintiff asks for a writ, then I may set it for a hearing, but I'm not putting that in the judgment so that Sarah doesn't see all that information.
Yes, Your Honor, I understand.
Okay.
Thank you.
And then ma'am, you also understand that you do have the right to have legal representation. You're choosing to represent yourself.
Yes, Your Honor, it's no need for that, but thank you.
Okay. And then counsel, if you can go over the court rule with Ms. Stevenson.
I did not go over the court rule, Your Honor, but I'm happy to do that right now. Ms. Stevenson, you are waiving your right to having a trial as to whether or not you do owe this rent. You have 3 business days to ask the court to set this judgment aside if you feel that it has been entered in error or you did not understand your rights under the judgment.
I understand. Yeah.
All right.
I agree.
All right, and then the court will sign that upon review, upon receipt.
Okay.
Thank you very much, Your Honor.
Thank you, Your
Thank you
Honor.
so much. Thank you.
Have a great
day.
Have a great weekend.
You too. Thank you.
You as well. Okay. All right, and then Mr. Hughes,